Okay, so welcome everyone, online and here in person. We may as well get straight into it because we've got a lot to get through in a really short space of time. So there's our general disclaimer, but if you want any specific advice, obviously reach out to us and we'd love to assist you with that in relation to your particular circumstances. Famous quote by Benjamin Franklin, and you're in safe hands with us because I deal with death and Shane deals with taxes. So this is our agenda tonight. So we're going to go through 5 key strategies in relation to estate planning. And the way I'd like to do that is by reference to a case study that's very close to my heart. But first we'll talk about the triple trap with estate planning. So first of all, who here online and here in the room thinks they have got an estate plan in place? That's a fair few people. I can't see you at home, but I'll trust you to make a mental note of whether it was yes or no. If you said yes, then you are correct. Everybody has an estate plan in place. So if you are correct, please email Chelsea your email address and a little surprise will come your way after this presentation. Now, the reason why you have an estate plan in place is because even if you don't have a will, you don't have powers of attorney, you haven't worked out the succession plan for your trust, your estate and your assets will still pass to someone according to the law. So in relation to your estate, it will be in relation to the laws of intestacy that's set out in legislation. In relation to your companies and trusts, it will be in accordance with those governing documents. And in making decisions for you, if you don't have decision-making capacity, it will be who VCAT appoints as your administrator or guardian. So even if you don't have the documentation in place, you do have an estate plan. The problem is it probably won't achieve what you want to achieve, and it won't be a very robust or effective one. So that's why when we talk about estate planning too, we talk about it being more than just a will, because your will only govern the assets that you own personally, and it won't govern the assets that are held in a company or assets held in a family trust. So it's more than just a will. And what we want to do is help you not become a war story. And we'll talk about a couple of war stories tonight. So the case study that we're going to talk about is my own, because we ask all of you to share a lot about yourselves and your family and your circumstances, your financial circumstances, your family dynamics and your personal circumstances, in order to be able to provide you with holistic advice and achieve the goals that you want to achieve. And you trust us with that information. And so I thought, well, what better way to explain estate planning than with myself and my own family and share a little bit about me. So these are my 4 gorgeous children. The little diagrams, the little figures there are in age order and also in height order. So Laura, who's the oldest and nearly 20, is the shortest, and Henry, who is 14, is the tallest. This is my family tree. So I have an ex-husband, my 4 children. I do have a partner, and I won't name him because he's in this room. You can stay anonymous if you want to. So that's my family tree, and I'll talk about that in reference tonight. So what forms part of my estate? Well, this diagram shows that there are some things that form part of your estate that are owned personally. So that might be property that you hold in your own name as tenants in common or totally in your own name, your personal belongings and chattels and items, shares, cash in bank accounts. That's by no means an exhaustive list, but are probably the key factors that form part of your estate. There are things that will always fall outside of your estate. One of them is jointly owned assets in that first instance. So if you, and it's most common to own, say, your family home in both couples' name as joint tenants or jointly. When one of you passes away, that asset will automatically transfer or vest in the surviving owner under the laws of survivorship. So jointly owned property will not form part of your estate or be governed by your will in that first instance when one of you passes away. It's only when the last surviving owner passes away, that it will then form part of their estate and be governed by their will. Same goes for joint bank accounts or jointly owned shares, which is probably less common, but that's a particular thing about jointly owned property that we need to keep in mind. Superannuation, and we'll talk a lot about superannuation a bit later, that doesn't necessarily form part of your estate unless you direct it there, and assets that are held in other entities like family trusts or companies, for example. So let's jump into one of our first strategies, and this is in relation to wills and the testamentary trust strategy that we'll talk about. As I said, your will govern the assets that are in your estate and how they are to be distributed. So one of the strategies we'll talk about are testamentary trusts. First of all, who thinks this is a will? Now, if you've seen this slide before, please don't answer. But who thinks this is a will? I can see Peter's brain ticking over, going through the legal elements of a valid will.
Sue thinks it's a will.
Okay, Sue thinks it's a will. So make a mental note at home again of yes or no, because whoever is correct will receive a surprise afterwards, and you'll have to email Chelsea. Chelsea, you're going to have lots of emails coming your way. So who thinks it's a will in this room? Okay.
It's not legible.
Okay, so it is in fact a will. It was in fact a will that was proven in Queensland. So it's in writing. It sets out the testamentary wishes of the testator. It's signed in the presence of two witnesses. You can see a registered nurse there, and I can't read the other signature. And apparently the diagonal writing across the middle says, I give my estate to Julie. Somewhere in there, it basically directs the estate to the person's wife, Julie. Does anyone want to hazard a guess as to why there are two dates on there, the 18th of July 1987 and the 17th of March? Get a bonus surprise if you get this right.
We wrote it on the 17th of March. We got the witness the day after.
No, we have to be in the presence of the two witnesses, so it can't be that. I'll put you out of your misery. He was a proud Irishman and he just wanted to make his will on the 17th of March, being St. Patrick's Day. So he put the 17th of March, but in fact it was signed on the 18th of July. As you can imagine, that will cost tens of thousands. I think it was something like $100,000 to actually prove. And why would you even bother? There was a large estate. And in Queensland, the intestacy laws operate a little bit differently to here in Victoria, and children share in the estate from the outset. So his estate would have been shared amongst the wife and children. And they didn't want that because the children were in situations where they didn't want to be receiving millions of dollars in their own personal names. And so instead, it was very important for them to direct the estate in its entirety to the wife, so that she, in her will, knowing that she would likely die afterwards, could establish testamentary trusts under her will for the children. So why would we put in place testamentary trusts? Well, a standard will, simple, cost-effective, you get your estate to the right people. It's not very tax effective, doesn't protect the beneficiaries and all the assets that go to the beneficiaries from family law breakdown, bankruptcy, and sometimes you need to protect beneficiaries from themselves and have a more protective trust in place. So standard will, sometimes it will meet the purpose, particularly for, say, young people that just need something in place to appoint key people to make decisions for them and be their representative in administering their estate, and just want to leave their assets to particular people. The testamentary trust approach, on the other hand, still gets your estate to the right people, but it does so in a much more effective way from a tax planning point of view, some family law protection, creditor protection, and you can structure the testamentary trust to protect beneficiaries, to be flexible, and to pass on assets to subsequent generations. Little bit more costly to put in place, And if you can get your head around the complexity of the document itself, which we would assist you with, then it can be a really effective estate planning tool. So let's talk about those key benefits in relation to testamentary trust. The first one being tax. So a testamentary trust, and I should have said this a bit earlier, is essentially generally a discretionary trust, but a trust created under the terms of your will. It's not set up now. It's established under the terms of your will when you die. So in your will, it will appoint a trustee to receive the assets or the distribution from the estate, and the trustee will make the day-to-day decisions about the trust and manage that inheritance on behalf of and hold it for the benefit of a range of beneficiaries. The trustee itself may in fact be a beneficiary, but it could also include a broader class of relatives, children, grandchildren, lineal descendants, and also other entities, so trusts or companies that person's associated with, and charities. So there can be a range of beneficiaries that can receive distributions from that trust. So it's not about taking away control of the inheritance from the beneficiary that you want to benefit. Sometimes there may be extra controls put in place depending on the circumstances, but generally with a fully discretionary testamentary trust, you're leaving your estate to the person that you want to benefit, but you're leaving it to them in a testamentary trust structure that's established once you die under the terms of your will, that is then managed going forward. And it's very much like a family trust or a discretionary trust in its nature, in terms of the discretion that the trustee has to make distributions, the discretion the trustee has to invest in whatever investments it wants to invest in. And so the terms and conditions of the trust are very similar to a family discretionary trust, but it's created under the terms of your will, and your will itself becomes like the trust deed. So one of the key tax benefits of a testamentary trust structure is being able to split income amongst a range of beneficiaries in the same way that you would with a family trust. But there's one important difference, and that is that the income that's generated from in a testamentary trust, as opposed to a family trust that you've established during your lifetime, is considered accepted trust income, which essentially means that minor beneficiaries, so beneficiaries that are under the age of 18, can receive income from that trust, and they're treated like adults for tax purposes. So they have the benefit of the tax-free threshold. So whereas with a family trust, the limitation is what, $416? Yep. They can receive up to, with the Medicare levy and so forth, maybe close to $20,000 tax-free. So I'll just jump a slide just to illustrate this with our example. So say Laura was to receive her 25% inheritance from me in a testamentary trust, and she, jumping quite a few years down the track, I hope, had 3 children. Suppose $1 million went into the trust, that was invested, very modest return, 6%, so $60,000 income she had to distribute in that year. If she had just received her inheritance outright in her own personal name, and those investments were made in her own personal name, that $60,000 income would be added to her own existing taxable income, and she would pay tax at whatever her marginal tax rate is. That could push her up into a higher tax bracket. She might already be in the highest tax bracket, hopefully for her she is, and half of it almost could go in tax. Whereas if it's in a testamentary trust structure, she could distribute to herself, but she could also distribute $20,000 each to her children, being minors, and they would virtually pay no tax on that. So as you can see, it can be quite an effective tax planning tool. I'm not sure how the changes with Section 100A impact on that. Shane, do you want to make any comment?
So I will, but very brief one, because we could spend a lot of time on this one too. So currently the ATO is issuing some guidelines on distributions out of trusts and how they should be taxed and whether they're valid distributions to children. And so all I'll say at the moment is that it's there's a guidance statement that's been issued by the ATO, which could restrict how we do distributions to minors through testamentary trust, but it's not law yet, and we're still waiting for further guidance from the ATO before we can give a categoric answer on how that should be, how that'll affect these arrangements.
And there are other options as well. There's
Yes,
the flexibility to distribute to a bucket company or a family trust that you've got set up. So it does provide that flexibility to distribute amongst a range of beneficiaries. There were some changes, I think a year or so ago, or maybe it might even be 2 years ago now because time flies, to that section of the Act, to Section 102AG, which basically limit what can go into the testamentary trust to just be the assets that are as a result of the death of a person under their will. So what that means essentially is that it has to come from the estate or any accumulations in, capital or income throughout that period. So you can change investments and change assets and that sort of thing, but that initial capital contribution into the trust needs to be as a result of the death of a person under their will. So what that means is post-testamentary gifts are a no-no. So you can't think, oh, this is a great, really tax-effective structure I've got going here, because I can distribute to my children, I can pay for their private school fees, etc., etc. I think I'll put another $500,000 into that trust and use it in that same way. You can't do that because it will lose the accepted trust income status. If all your children are grown up and you've got no minor beneficiaries to worry about, and you want to treat it just like a normal family trust, then sure, there's nothing to stop you putting other funds into the trust, but it will lose that accepted trust income status. So that's just something to be mindful of. And I don't want to get technical here at all, but in case anyone's wondering what happens in relation to, say, a property that goes from a person into an estate, into a testamentary trust, what that happens from, say, a capital gains tax point of view, and whether that triggers that along the way. And Shane, feel free to jump in with any technical stuff here. No, there's CGT rollover relief, and there have been rulings that have confirmed that an asset that goes from the deceased person into the estate, into the testamentary trust, and even ultimately to a beneficiary of that trust is CGT free, or there's rollover. So it means that the cost base, it's deferred essentially. So the cost base is the original cost base of the deceased person, and it just rolls over through all of those stages. If you've got a pre-CGT asset or a main residence, for example, that then it becomes an investment property, then it's the value as at the date of death.
Correct. Yep.
The other interesting use of testamentary trust, and it's particularly relevant nowadays when our family members go off overseas and live overseas and travel all over the place, and so become foreign beneficiaries. And so as part of your estate planning, it's really important to think of, well, what happens if I leave assets to my child that's no longer an Australian resident and is living overseas? Testamentary trust can be a useful tool in relation to that. So say, for example, you have a child living overseas, foreign resident, and you want to leave a portfolio of shares to them. That would be non-taxable Australian property. And by leaving those shares to a foreign resident beneficiary, that would trigger capital gains tax at that point. So testamentary trust can be used as an effective tool for that beneficiary to receive that portfolio of shares if you make it an Australian resident trust. So have a trustee that's an Australian resident, or a company where the management and control is in Australia. So that's another thing to remember that might be relevant for a lot of people. So a picture tells 1,000 words. You'll notice I use a few pictures rather than have content. So the protective nature of the testamentary trust structure is another powerful reason to put it in place. So from a creditor's point of view, bankruptcy point of view, the assets that are in a testamentary trust are pretty much protected from a trustee in bankruptcy, unless the trustee is silly enough to actually make a distribution to the beneficiary. It's pretty much bulletproof against that. Another big concern of particularly parents leaving estate inheritance to their children is that that child will experience a relationship breakdown, get divorced or separated, part ways, and the wealth that they've spent a lot of years and time and expertise accumulating over the course of their lifetime ends up being divided between their child and an ex-spouse. So testamentary trust can be one way of minimising that risk. So the family court, as we all know, has very wide-reaching powers to look behind any sort of structure. So trusts, companies, things, assets that are in other people's names, and pool all of those assets together and then divide them up between the parties. But with assets that are in a testamentary trust, the family court, the cases have shown that the family court will either ignore it completely, and that normally comes down to a question of control, who's in control of the trust, so, and also the range of beneficiaries. So the less control you individually have over that trust and the less and the more beneficiaries that could potentially benefit, the more protective it can be. So they'll either ignore the assets in there or they might see it as a financial resource. So let's suppose it was Oliver received his share of my estate in a testamentary trust. His relationship broke down and he got divorced. The assets that the court might say, well, Oliver, you have this testamentary trust, you potentially could receive distributions from that this testamentary trust. So we're going to look at it as a financial resource for you to rely upon when we're looking at the ability of the parties to, fund their lifestyle, to maintain themselves. So we'll look at it as a financial resource for you, but it won't form part of the pool of assets that are actually divided between Oliver and his ex-partner. So in that way, it can sort of protect that family wealth from relationship breakdown. It's important to remember that testamentary trusts there are a myriad of different ways you can structure a testamentary trust, and this is where it really is a case-by-case basis to sort of suit your individual circumstances. So one size does definitely not fit all. You could have, well, that's a slightly more recent photo, they're even more grown up now, but you could have single or multiple testamentary trusts. So if my kids were the age that they are in that top picture, which is probably about 12 years ago or something like that, then I'd probably just create one testamentary trust for them as together and as all beneficiaries of that trust, and appoint someone to manage that for them while they're still young. When they're all grown up and financially independent, doing different things at different stages in life, it would make more sense for them to be in control of their own inheritance, both from a conflict point of view between each other and legacy point of view in terms of their children or grandchildren all having to work together in this one trust structure. But there might be other reasons why you'd have one or multiple, like the amount that's going into it, or whether it's something that you want to be a family asset ongoing, say a holiday house or something like that. So there are all sorts of considerations there. You need to consider control. Do they have the acumen, are they sensible enough to control their own trust, or do they need someone independent in there with them, helping them and supporting them make decisions? And I know Shane's appointed in a lot of circumstances with his clients to that trustee role. Do you want to put an appointer or a principal, sometimes they're called, into the trust, so to oversee the trust? And basically the appointer's role is to hire and fire the trustee. So even if you leave your child in control of the trust, maybe there's someone that oversees that so that they can control that trustee position if necessary. You can restrict the beneficiaries to a bloodline trust, although I think that's actually a registered trademark to Cleary Hall, so lineal descendants trust, or you could have a broad range of beneficiaries, including, aunts and cousins and siblings, for example. You can have companies as beneficiaries, trusts, charities. So you can limit the beneficiaries if you want to, and it can take all sorts of forms. You could have a more protective trust if there's someone with a disability or that's vulnerable, or a spendthrift. You could preserve the capital for the lifetime of a particular beneficiary or for a certain number of years, or you could provide guidance around that in a memo of directions and leave it legally flexible, but provide guidance about what your thinking is. So there's some of the options, but as I said, the options are endless, and it really does depend on your particular circumstances how we would suggest you structure it the best. Does anyone have any questions right now about testamentary trusts, or do you want to save them? What's easiest for you, Chelsea? Do you want to save them till the end, or? Okay. Does anyone have anything they want to ask about that? Or we'll jump into superannuation? Yes. Yes.
How long can they stay?
Okay. Yes, so Graham's just asked how long the assets can stay in the testamentary trust, and good question. I normally say that in my little spiel, but I forgot. The maximum period under law is 80 years, just like with a family trust. So yes, 80 years they can potentially stay in there, but there might be a time where it doesn't make sense for them to still be in the trust structure. 80 years from the date of death, I should have said. There might be a time where it doesn't make sense to keep it in the trust structure. So, for example, if the laws change, as Jane was talking about, and just distributions of income are no longer, you're not really getting that tax benefit out of it, or you're sort of a couple of generations down the track, and so you've got 20 people that are all trying to decide what to do with this trust structure, or the capital is dissipated over the years. And in that situation, the trustee might decide to wind it up. So they simply need to bring forward the vesting date, either by resolution or deed. We'd probably suggest by deed, even though under the terms of the trust that we produce, you can do it by resolution. So bring forward the vesting date to whatever date you want. It might make sense to do it at the end of that financial year or something, so it's all clean. Do final tax return and for the trust, and distribute out the capital to whichever beneficiaries you want to distribute it out to in whichever proportions, and wind it up.
Sophie, can I just ask?
Sure.
You said that the assets result from something.
Yes.
So in terms of the house and things like that, in terms of discretionary trust, other structures, you have structures where the person died isn't told. So should be told. Can the others where they're part?
And
just talk about that.
Yeah.
What other assets still fit the umbrella?
And that's a great question. We just asked what happens with the other assets that are not personally owned, that go into the trust, so things that might be owned by a family trust or a company. And that's one of the strategies we'll talk about, I think maybe number 4. So maybe we'll park that until then, and then if I haven't answered the question, please jump in and say you haven't answered my question, Sophie. Yes, Ash.
Can you give option?
Yeah, so some people will have it as an opt-in. Sorry, Ashley just asked if you can have it as an option to create the testamentary trust. You can have it as an opt-in, but what we prefer is to have it as an opt-out, really, and in that there is the ability under the terms of the trust deed to distribute that share directly to a beneficiary. Say, for example, especially, and would probably be the most relevant example, say they had a disability and that inheritance or that part of the estate could be set up in a special disability trust. You'd want to avoid that normal sort of testamentary trust structure and put it into a special disability trust. So you can avoid it by almost winding up the trust before you've even started it. But we like to have the default position as the trusts are being set up, because it also makes it less likely that it could be challenged by a beneficiary. So if one of the beneficiaries wants to say, I don't want it in this testamentary trust structure, I want that $1 million in my which they may well do, but you've gone to the trouble of setting up this whole structure to protect them. If it's an opt-in, it's more easily avoided by the beneficiary.
Or I think the executor, giving the executor the option.
Yeah, but it still would be easier to challenge. So we have it as the default position that you set the testamentary trust up, but it can be avoided virtually at the time when it started. So for example, and that might happen if you've got a husband to wife or wife to husband, where you leave your estate to each other, but you leave it in a testamentary trust structure. But there might be virtually nothing going into it, because if all the property you own, and Peter and I have spoken about this over the last couple of weeks, if all the property you own is jointly owned property, or it's in superannuation or other assets that are outside of the estate, what would go into that testamentary trust might be virtually nothing. It might be, you know, $20,000 in a bank account or something, in which case it wouldn't be worthwhile. So it would be better just to avoid that structure. So good question. And all of those things can be built into the terms of the trust.
Do you mind? The executor the option to go down the path.
Yeah, and that's fine. I'm happy to have a look at yours and tell you what I think. Let's have a talk about superannuation, and we'll just talk about a few key things here, because superannuation is complex, huge, so many different options, and the strategy around it, both during your lifetime, you know, as Shane can attest to, and with James, our financial planner as well, during your lifetime, the strategies that you adopt in relation to superannuation, but also as a result of your death, are really important, and there are lots of options there. The key thing to remember is, is that superannuation isn't necessarily covered by your will unless it's directed to your estate. So as we said earlier, your will only govern the assets that you personally own. You don't own that superannuation. It's a death benefit. It can be directed to your estate, but it won't necessarily go to your estate. So that's the first thing to consider. Superannuation could stay outside of your estate. There are a few key things that we look at with succession of your super, and I'm mainly talking about self-managed super funds here, but we need to look at, well, who can benefit, the control of it, like who's making the decisions about where it goes. Can we direct the superannuation to go in a particular way via binding death benefit nominations? There are other options around that, like you can have a superannuation will, and that term has different meanings to different people, but I generally think of that as it being the succession mechanism for the death benefit to be embedded in the deed itself. Reversionary pensions, which is a little bit like a jointly owned asset, it automatically reverts to the beneficiary. With all the changes, you've got to consider the transfer balance cap, and you know, whether you roll back your pension into accumulation and then take a death benefit pension. It's really complex, and so we won't go through all of that now. It just is, I guess, to give you a bit of a taste of the various options and the complexity that can be involved. The key things that we'll talk about today are control of the self-managed super fund, binding death benefit nominations, and we'll also talk about the hidden death tax or superannuation death benefits tax, because we don't have death duties or inheritance tax here in Australia, but the way that you get charged tax is through your superannuation death benefits. Important in all of this, because any strategy we put in place, we can only do it if the superannuation deed, and I'm talking about SMSFs here, but if the deed allows for it. If the deed doesn't allow for it, we can't do it. So it's important to make sure your deed's up to date and that it does allow for the strategy that you're putting in place. Sometimes, and I'll just touch on this last point now, but sometimes it actually makes sense to keep super out of your estate. You know, often we'll direct it to your estate so it can fund the testamentary trusts, but sometimes it does make sense to keep it out if there potentially could be a family provision claim. So where someone challenges your will and says, I should have been provided for here, I haven't been provided for, Supreme Court, please redistribute the estate and provide for me as part of it. So if the super is outside of the estate, then it doesn't form part of the pool of assets that can be redistributed amongst the beneficiaries. Also, if you've got a blended family and you might want to make sure that, say, your children benefit from your super, and we'll see this with an illustration of my super in a minute, so I won't go into that in too much detail. But be aware of if you're in New South Wales, and I don't think we have anyone in New South Wales online tonight, but someone who may watch it, if you're in New South Wales and they have notional estate provisions, which does take into consideration your super in a family provision claim, so it's not as effective in avoiding that in that situation. But who can benefit? And this is relevant not just for SMSFs either, it's relevant for any super. So if you've got super in Australian super or first choice or whatever it might be, who can you actually benefit if you die? Who gets your super? So they have to be a superannuation dependent. So that's a spouse, a child, someone in an interdependency relationship with you, which is a close personal relationship where there's some form of dependency between the parties, or your legal personal representative, which is basically your estate. So it goes into your legal personal representative, who's your executor, and then it's governed by your will. They're the only people that can benefit. So I've seen many situations where people have done a nomination with Australian Super or whatever fund it is and put their parents down. So particularly for young people, and I'm looking in your direction here, Laura, Chelsea and Chantel, particularly for young people, they'll think, oh, you know, I don't have a partner, I'll put down my parents, or I'll put down my, or if you're older, I'll put down my grandchildren. I'd love my grandchildren to benefit from my super. It's an invalid nomination. And the thing is, with industry funds or retail funds, they don't check the nominations. They've got too many of them. They don't always, some might, but they don't always check that you've actually nominated a superannuation dependent. So it's not until that person dies that it's okay, the nomination's invalid, and then it would just be up to the discretion of the trustee of that super fund as to where it's directed, and it would most likely go to the estate. But in doing a will, say, you might have taken into consideration that, oh, I've left my super to my parents, so therefore under my will, I'll leave my other assets to someone else. So it's important to know who you can leave it to. Then there's another definition just to make it really confusing, and that's tax dependence or death benefit dependence. And that relates to if certain people receive the super, and whether that's via the will or whether it's directly, how that super is treated from a tax point of view. And I think this is, oh, no, we're not quite up to your bit. Sorry, Shane.
That's all right.
You have to wait a bit longer. So we'll talk about that tax bit in a minute. But in relation to control, with a self-managed super fund, if there's no nomination in place or nothing to direct the trustee as to how they have to distribute the super, then it's up to their discretion. So there are so many cases on this and so many war stories, but we'll talk about the original, Katz and Grossman. So mum and dad, co-trustees of a self-managed super fund. Mum dies, dad nominates or appoints his daughter as a co-trustee, because with a self-managed super fund, you have to have at least 2 individual trustees. And so daughter and dad in control of the super fund. Dad makes a non-binding death benefit nomination, so it doesn't have to be followed. Dad dies, daughter has to have a co-trustee, appoints husband as co-trustee. So you've got daughter and son-in-law as trustees of the self-managed super fund. Daughter and husband decide not to follow the non-binding death benefit nomination that dad has done, and instead distribute the entire superannuation to the daughter instead of equally between the daughter and son, which was the intention. Son challenges that, sues, was unsuccessful. The trustee properly exercised its discretion in favour of the daughter to pay the death benefits to her and her alone, at the expense of the son. There have been some more recent cases that have qualified that discretion to a degree in requiring the trustee to give just and reasonable consideration to their decision, but it's still been upheld that the trustee has that discretion. If you want to jump in at any point, Christian, you're quite welcome because he's our expert on that.
Nailed it. That they could potentially challenge that decision
Nowadays,
by saying the trustee exercised their duty of bad faith rather than attacking the BDPA.
Yeah. So what Christian was just saying for those at home was that nowadays, and this might have been decided slightly differently, if they had exercised their discretion in bad faith, then it might not have held up in the way that it did all those years ago. Yes, Chelsea.
I have a question from Sue at home who's asked, should our adult kids nominate as super dependents?
So, well, they can only nominate a spouse, a child, someone in an interdependency relationship. That's quite difficult to prove, so I wouldn't suggest that, or the estate. So if they don't have a spouse or children, then the estate. And that is the way that it would probably go naturally anyway. But if they want to make it clear, it would be the estate. And then they should make sure that their will directs that superannuation in the way that they want it to go, either by specific reference to the death benefit or just generally it would form part of the estate.
We also have from Alex, what is an intergenerational relationship?
Well, crossing generations, I guess. So like a parent and a child, grandchild. Yeah. Oh, that was just a question about intergenerational relationships. Sorry, I forgot to repeat the question. So in relation to the lessons, I guess, from Katz and Grossman are that the trustee is in a very strong position of control because it can exercise its discretion. So there are a couple of things that they could have done differently there in Katz and Grossman. Dad could have appointed a corporate trustee instead of appointing his daughter as a fellow individual trustee, because you can have a corporate trustee where there's one director. And so then it would have just been up to his executors, who would step into the role as his legal personal representatives as directors of that trustee company to wind up the super fund and distribute the proceeds, and the executors were both the children. So he could have had a corporate trustee in place to avoid son-in-law getting involved in the whole process, or he could have done a binding death benefit nomination instead of a non-binding one. Non-binding one is really a direction as to your wishes. It's and the trustee has to give due consideration to, but doesn't force them to distribute the benefits in that way. So we normally suggest that you do a binding one, make a call on it and do a binding death benefit nomination. The requirements for that are that it's in writing, signed by 2 independent witnesses. You need to obviously be able to identify the member, which shouldn't be hard. You need to be able to identify the beneficiaries and their interests. So, you know, you need to make sure it actually does add up to 100%, for example, or you might have a portion of your super that's then sort of sitting there undistributed. Does it go into the estate? So identify the beneficiaries. Most importantly, though, it has to comply with the deed requirements. So read the deed. So because sometimes the superannuation deed itself will have certain requirements built in, like, for example, that it needs the approval of a particular person, or the trustee has to accept the binding death benefit nomination before it's valid. So, for example, even with Macquarie, so not a self-managed super fund, obviously, but with Macquarie's super platforms, they have on all of their nominations that it's not binding until they've actually confirmed that it's accepted by the trustee. So it's important that you comply with requirements. Back in, 2014, they changed it so you didn't have to, they didn't automatically lapse after 3 years. Previous to that, binding death benefit nominations lapsed after 3 years, so you had to keep renewing them. You can do a non-lapsing one now, but only if your deed allows it. So you need to make sure your deed's up to date and that it allows for non-lapsing nominations, so you can do it. You don't have to, you should always keep an eye on it and review it, but you don't need to update it every 3 years for it to be valid.
Just on that, be careful though, if your circumstances change and you've got a non-lapsing nomination, and that person who you've nominated may not be the appropriate person anymore, you need to update that as soon as those circumstances change. So don't, it's not set and forget.
No.
Yeah, it's got to be
As
top of it.
none of these things are
Yeah,
in
correct.
estate planning. So as part of reviewing your estate plan, and we'll talk about that further on, you should, review all elements of it. You can be quite creative and complicated and technical with the binding death benefit nominations. They can be cascading. So have, I leave it to my spouse, but if my spouse doesn't survive me, I leave it to my children, or I leave it to my estate. So you can have it, like a will, with different layers. You can prescribe the form of payment. So you can say it has to be paid as a lump sum, or it has to be paid as an income stream, or you can even make in specie distributions. And I know Graham and I have spoken about this recently, about making in specie distributions of from your super fund, but only if your deed allows for it. So it's really important to check that as part of it. And the technical requirements, I know I've been going on about this, but it is so important with binding death benefit nominations. So we'll talk a little bit about Monroe and Monroe. Mr. Monroe was a lawyer, a lawyer in a second relationship. He had a template binding death benefit nomination provided to him by his advisor, and being a lawyer, he didn't need any help completing it. So he filled out his binding death benefit nomination, had it witnessed properly with 2 witnesses, and he had nominated the trustee of his estate, because in his will, he then distributed that as part of his estate to his children rather than to his second spouse. So he died. Second spouse thought, I don't want to leave it to the estate. I'll distribute it to myself. Exercised her discretion to distribute it to herself. The binding death benefit nomination was found to be invalid because he had nominated the trustee of his estate, and it should have been left to the legal personal representative. So just by using the wrong word, we all knew what he meant his estate, but because he said trustee of estate instead of legal personal representative, which is a legally defined term in legislation, it was found to be invalid and didn't have to be followed. So it's really important to comply with the technical requirements.
Question from
Yes, Chelsea.
This is for me. So is this why it is not recommended to use things like will kits, like kids, because things like that could be overlooked?
Yeah, well, definitely the will kits is probably better than not having a will at all, because at the very least it might appoint an executor, but it certainly wouldn't take into account things like your superannuation, which sit outside your estate, or any other assets that you hold in other entities, which we'll talk about in a minute, because I know that was one of the questions. So will kits are probably better than nothing, but even if you got a will kit, you would want assistance setting it out, because 9 times out of 10 they're not completed correctly, and they certainly don't take into consideration these other factors. Shane, do you want to have a turn?
Thank you. I've been so looking forward to this. I'm going to actually scroll back.
To talk about tax.
I do. I'll scroll back a little bit just so we can see what the definitions are about tax dependents. So on the right hand side there, so tax dependents, these are the people who will qualify as a dependent of you for the purpose of the transfer of superannuation benefits on your death for tax purposes, okay? And this is where this hidden death tax comes in. So just have a quick familiarisation again with those different people who might qualify. The key one I will highlight in this respect, because spouse is pretty straightforward, children under 18 straightforward. The children 18 to 25 and dependent is one of the ones that can be a bit grey. So what that means is they might be at university and they're still financially dependent on it. If they're out on their own, they've got their own house and they're earning their own income, they may not qualify as a tax dependent. So when you then go to this taxation consequences of your death and superannuation benefits, I'm just going to run through some of the items in here and how that would actually work. So within superannuation, again, I'm not going to try and get too technical. There's 2 different components to superannuation. There's the taxable component, and then there's there's 2 parts of that. There's the taxed component and the untaxed component, and then there's a tax-free component. I'm just going to concentrate on what we call taxable and then tax-free. But basically, when you direct a death payment from a superannuation fund, the tax-free component is tax-free when it goes to the beneficiary. So if everyone wants to have a look at their member statement they get from their superannuation fund, it will break it down between what's in their taxable component and what's in their tax-free component. So the tax-free component is tax-free, as it says here, on a lump sum payment to a non-tax dependent and also a tax dependent. So, and then the other part is the taxable component. You'll see that if it goes to a non-tax dependent, there is a lower of either the marginal tax rate of the person or 15% tax rate on the tax component brackets tax. So that means where you've made concessional contributions, so contributions into your super fund from the employer and things like that, that'll be a tax component. If that goes out to a non-tax dependent person, the super fund, before it passes that benefit down to the beneficiary, there's 15% tax on that tax component. So give an example, you might have, I think I've got that later actually, but yeah, so that's an issue. But so you just got to be careful about whether they qualify as a non-tax dependent or a tax dependent, because that can have a significant impact on your tax liability, which we'll show in a minute. Income stream, I won't go into too much detail. It's pretty much the same, same thing. Yeah, and it's far too complicated for today. We can spend hours on this. So the hidden tax, and this is what I'll just go through now. So we've got a situation here where we had a client with a member balance on 1 July 2022. They had a tax-free component of 100,000 and a taxable component of $1.6 million. So the breakdown between that for John is 94% in the taxable component. And then Agnes has got no tax-free component and she's got 500,000 worth of taxable component. If John was to pass away and he was to allocate make a nomination to go to a non-dependent, then he'll have a tax liability, or the super fund or his member balance, the tax liability on that will be 17%, which is a 15% rate we talked about before, plus then they add Medicare levy to it as well. So 17%. So that means the estate, or who he passes down to, they're going to have 272,000 less than what they might have anticipated because of that tax. And that's because of that taxable component. In Agnes's case, with 500,000 in her fund that's taxable, the tax on that 15 or 17% is 85,000. So it's really important when, I know we shouldn't do things for tax purposes, but when you're considering who your beneficiaries are of your superannuation balance through those nominations, it's important to consider whether they meet that definition of a tax dependent or a non-tax dependent, because it can have a significant impact on the taxation consequences. So therefore, as Sophie said, with other matters, you've got to look at the total pie and look at superannuation versus the other parts of the estate to work out, okay, we know that there's potential this tax liability if this superannuation goes to this person. So then look at maybe whether other assets from other parts of the estate should go elsewhere, or the mix would change to ensure that we're minimising that tax liability or this hidden death tax that comes about. There are also strategies that you can adopt, which is called a recontribution strategy, which you can actually work while you're alive to reduce that taxable component in your balance. I'm not going to go into today because again, it's very complicated and would take quite a long time to go through, but there is strategies that you can adopt, and that's where James, our financial advisor, can help you with that, because that's part of the financial advice piece, but that's a way in which you can reduce that taxable component while you're alive to basically mitigate or reduce that exposure to that hidden death tax.
John can spend the money.
Yeah, that's the other thing too. You spend all the money before you die. If you can work it out before you die. Actually, just quickly on that, one last thing. Had a situation with a client who passed away 3 weeks ago. He had a substantial amount that was a taxable component. He was very unwell, and we knew that he was not going to last for much longer. So before that, we interacted with the financial advisor and we liquidated a lot of the assets that were sitting in his superannuation fund that we could easily liquidate. And we withdrew those out of the fund before he passed away, because when you withdraw those funds out of the super fund before you pass away, that eliminates that death tax because it's no longer sitting in the superannuation environment.
Just part of your estate.
It's just part of your estate. So that then forms part of your estate.
As per your will.
So that was a strategy we adopted because we could plan it a little bit, because we knew that he was sick, but he hadn't passed away suddenly. So we could then put in the strategy in place, and that saved his estate roughly about $120,000 in tax. So it was quite substantial.
So if we just look at that in the context of an example, so with my super, say for example, I could either leave it to my partner, assuming we were living together, but which we're not, but then, and it would be received by him tax-free as a partner. So that would be probably the best scenario from a tax point of view. But then when he passes away, it would form part of his estate. and would be distributed as per his will. So that might not achieve what I would be wanting to achieve in benefiting my children ultimately. We could have, say, mutual wills, a contract that we're not going to change our wills and we're going to keep it how it is, or in the will say whatever super I've received from Sophie, then that's to go to her children. But that's quite complicated because that sum of money can be dissipated and spent and change forms and be very hard to trace over the course of a lifetime. So from a tax point of view, and this is really to illustrate that tax is not the only driver in making these decisions, from a tax point of view, it would be sensible to leave it to my partner. I could leave it directly to my children, 25% each. But the problem with that is, yes, they'd have superannuation death benefits tax, 15% plus the Medicare levy on the taxable tax component. Life insurance through super attracts 30%. So life insurance through super, you get taxed even more. So I could leave it to the children. One issue with that is there's no gift over of that share of the super that they receive. So say, for example, Claire is meant to receive under the nomination 25% of my super, but she's passed away before me. Touch wood, that doesn't happen, not the natural course of things, but she dies before me. Her children would not receive that 25% share because I can't leave my super to my grandchildren. So that 25% share would be unaccounted for, would just form probably part of my estate. So there's no gift over of that superannuation if something happens to one of those beneficiaries. There's also no asset protection in the way they receive it. They're just receiving it in their own personal name. So for all those reasons we talked about the benefits of testamentary trusts, you wouldn't get those benefits. On the flip side, there might be a really good reason why I want to keep it out of my estate. I might be worried about a challenge of my will from my partner. And so I might want to just leave it directly to my children so that there's no, so that it's not part of the estate and not, can't be the subject of a challenge. Probably the most, sensible way to do it would be to leave it to my estate and then it's distributed according to my will. So if I've set up those 4 testamentary trusts, I've got financially independent children, there's going to be superannuation death benefits tax anyway. It can go into the various trusts. Yes, there would still be that superannuation death benefits tax. It would be excluding the Medicare levy, so slightly different. And if there did happen to be a death benefit beneficiary or a tax dependent beneficiary, then in our wills, in our testamentary trust wills, we actually have a special clause that quarantines that super in a testamentary trust for the tax dependent so that it can be received by the testamentary trust tax free. So there are more options with the testamentary trust, and as Jane touched on before, it may make more sense for the executor in distributing the assets to say, okay, well, this person is a tax dependent, we're going to give them their 25% share as in the form of super, and we're going to satisfy the other beneficiaries' 25% shares by way of other assets. So it gives that flexibility as part of the will. Does anyone have any questions about that before we? Because I know I'm already keeping you over time. Are we good, Chelsea, for time? Yes.
I was just going to ask, so if you want your superannuation assets to go into a testamentary trust, in your binding death benefit nomination, would you have to nominate your estate as opposed to your children, for argument's sake?
Yes, because if you left it to your children, it would be that second line there. It would go to them personally. So if you leave it to your estate, but remember, not your estate, your legal personal representative, it would go into your estate, be governed by your will, and then the testamentary trust would be created as part of that, either just as part of the residue, because if like the net estate is just divided into the trusts, or you could specifically say, because there are superannuation proceeds trusts, for example, you could specifically say this superannuation is to go into this trust that I'm creating under my will. And you could also have in specie distributions as well. So say a property goes in a particular way, or like part of your super, as long as it's paid out, death is a cashing event, has to be paid out of your super. If it's going to a spouse and you're taking it out as an income stream, still coming out. It's just that it's over a longer period of time. So it has to come out one way or another, whether it's as an income stream over time or as a lump sum. If it's as a lump sum, it could possibly be by way of in specie assets if you don't want to have to liquidate those assets, as long as your deed allows for it. So we'll get on to the topic that I was asked a question about before, and that's passing over control of other entities. So let's talk mainly about companies and trusts here. Any assets that are owned by companies or any assets that are owned by trusts will continue to be owned by those entities if a key person in those structures dies, even if they're a controller, one of the controllers. So even if they're a director of the companies, or even if they're a trustee or an appointer of the trust, those assets or the business that a company operates will continue to stay in those entities if somebody dies. So we need to look at other ways of making sure that the benefit of those structures passes in the way that we want it to pass, that aligns with what we're trying to achieve overall. So we'll have a little look at, say, a business that's run by a company and what we would call business succession planning. So one of the key things to look at is the governing documents for that company. So we need to look at the constitution for the company and the mechanism for, say, appointing directors. If it's got a tailored constitution, that might be different from the norm. Otherwise, it would generally be that the shareholders appoint directors. Shareholders agreement. So if you've got, multiple parties in a business, like here at Aintree Group and Aintree Group Legal and Aintree Group Wealth, shareholders agreement, which sets out the rules for governing their relationship and things like exit strategies, or what happens if someone dies, or what happens if someone wants to retire. So it governs the relationship between the parties. Or buy-sell agreements. So you might have a compulsory acquisition of shares and sale of shares in the case of someone's death. So if someone dies, rather than their estate or their spouse or their family trust or whatever it might be continuing to own shares in that business, there might be a buy-sell agreement in place which forces that shareholder to sell their shares to the continuing shareholders and forces the continuing shareholders to buy those shares. So it's an automatic mechanism that is often insurance funded, because otherwise you have to come up with the money to do it. So it's often funded by insurance. So it's important to look at those governing documents and make sure that they're set up in the way that you want them to be set up, and that you follow the procedures that are in them if someone dies. The other thing to look at with company succession planning or business succession planning is to eliminate any bottlenecks in the decision-making process. Ordinarily, so if shareholders appoint directors of the company, the directors make the day-to-day decisions about the company and are the signatories, and sign contracts and can make transactions, and so operate the business on a day-to-day basis. If something happens to one of those directors, it's not automatic that their executor just steps into that position. What actually has to happen is the executor, or if they've lost capacity but are still alive, the attorney steps in to control the shares that person owns in the company and then appoints a director. So there's a process involved there. It's not just an automatic, oh, that director's died, okay, executor step in. There's a little bit of a process there, particularly when you consider that you might have to go through probate and in order to have the authority to do those things. So you could look at putting an enduring power of attorney in place and a will in place that appoints your executor, appoints attorneys to take control of the shares and then appoint directors. But you might also want to consider putting a corporate power of attorney in place, which just provides a much more streamlined process for others to make decisions for your company if something happens to you, particularly if you're a sole director. So if you're a sole director and something happens to you, who's going to step in? Who has the authority to step in and just continue operating the company when there's bills to pay, there's money to be transferred, there's contracts that you're in the middle of negotiating and signing? So particularly if you're a sole director, it's a much more streamlined process rather than going through that take control of the shares, appoint a director, which also creates some uncertainty as to who's going to be appointed as director. If you put a corporate power of attorney in place, that person has the authority to act on behalf of the company if something happens to the key person. And it's actually the company making that power of attorney, not the individual person. Yes, Graham.
So if you've got a company, sole shareholder and director,
Mm-hmm.
in your account to that process,
Mm-hmm.
can you just say at point?
You can direct your executor that you wish to appoint that person as a director. So if it might be a child, it might be a business associate, it might be the executor themselves, but they would still be doing that as the representative of your estate and therefore the controller of the shares. So they would actually be doing it as the shareholder and representing you in owning those shares. So it's still a little bit of a process, particularly when you consider applying for probate and all of those sorts of things, which, you know, it might be fine with most decisions, but things like banks, for example, they won't just take your word that you're the executor until you've got the grant of probate that says you're legally appointed. So it can create some roadblocks and just make it a little bit more problematic in running the company the way you want it to run. But yes, definitely your will still has a place, both in terms of who the shares go to, because you might want to say you've got, particularly if you've got a family business, say, and some children are involved in the business, some aren't, that opens up a whole another discussion. But you might want to direct the shares in a particular company in a particular way, or you might want to direct them equally between testamentary trusts, or you might want to direct them to your spouse. Yes, Chelsea. Oh, Graham, what was the question?
Can you appoint directly in your...
Yes, so can in your will you say, I appoint so-and-so as a director of this company? And the answer was no, not really. You can express your wishes, but they still would have to go through the process of taking control of the shares. So there.
So,
yes, actually.
so once again, it's probably better that you appoint the person as a director prior to passing, if you've got enough time.
Or have a corporate power of attorney in place, because if you appoint them before you die, then they're in control of the company as well before you die.
Yourself, director, and just appoint a spouse, then might make it easier.
Well, if you're happy for both people to be, Ashley just asked about appointing someone before you die, and you can do that if you're comfortable with both parties being in control of the company while you're alive. Certainly, if you have notice of your death, a little bit like taking the super out before you die, if you have notice of it because you know you're terminally ill and it's not far away, you'd probably put in place those arrangements. In fact, we've got a lot of clients where, particularly if they're very elderly, parents, where they've already taken these steps before they've died to transfer control of their companies or trusts over to the children beforehand, because also there's an element, you know, once they start to lose capacity as well, or they just don't want to have to sign off on all those decisions.
I'll need director IDs.
Yeah, they will need director IDs. So there are other things to consider too, and I won't go through them now because they're more, you know, making sure that people know what your wishes are in relation to the succession of your business, what your intentions are, maybe key people to contact, you know, the plan that you've put in place for your business to continue on or be sold or be managed after you die. But let's talk about trusts. Now, this is, I think, my final question where you get a surprise if you email Chelsea and get it right. And I am trusting, because we're talking about trusts, I'm trusting everybody at home to be honest about whether they really did get the answer. If you know the answer, if you know the year that A Matter of Trust by Billy Joel was released, email Chelsea.
Don't Google it. Yeah.
Don't Google it. So I'm trusting everybody at home. I can see everybody here, so I know they're not Googling it. Don't Google it and be honest about your answer. But I'll give you a minute just to think of your answer.
Billy Joel.
Billy Joel.
Sue has a guess.
St. Barnes.
Some of the younger people might say, who is Billy Joel?
Yeah.
Yeah.
Although he's made a resurgence with
You
Vienna.
have to give us a few verses.
He's it's always been a matter of trust. Dun, dun, dun. Oh, I forgot this is recorded.
Yes, it is.
Okay, well, we'll share it with you. What was Sue's guess, Chelsea?
She has guessed 1978.
Oh, no, a little bit later than that. Close. 1986. So if you got 1986, ping Chelsea with your email address and she'll pass that on to me and you get a little surprise later. Okay, so let's talk about trusts, which was relevant to the question we had at the beginning. It's taken us a while to get there. One thing to remember is, okay, so any assets that are held in the trust continue to be held in the trust if a key person within it dies. If you want the assets in that trust to go to a particular beneficiary or beneficiaries, keep in mind that changing the beneficiaries of that trust may trigger a resettlement of it, may trigger capital gains tax. So you can't just like change the beneficiaries if something happens and it creates a new trust essentially. There are also issues with splitting the trust, so which a lot of people would like to be able to do, and you did used to be able to do, but having a trust and then saying, okay, well, this trust is going to now transform itself into 4 separate trusts, one for each of my children, and certain assets are going to go into each of those. Even, you know, it's even difficult to appoint sub-trustees to each of those parts of the assets. That will also trigger a capital gains tax event. Distributing assets out of the trust will also trigger capital gains tax. So if you have an investment property in your trust and you want to distribute it to a beneficiary of that trust, you can do that in Victoria at least, and in most states with nominal duty. In Victoria, you can do it without stamp duty, but it will still trigger a capital gain. It will still trigger capital gains tax. Unless, of course, it's a pre-CGT asset, but then you might not want it out of the trust because then it will start to accumulate capital gains tax. So, you know, in planning for what happens to the trust, the main thing we look at is control. So whoever is in control of the trust essentially can make the decisions about the trust, has control of the assets, can decide to buy or sell, can make distributions, so could make a capital distribution to themselves. So whoever is in control of the trust essentially inherits the trust. So we need to look at 2 key roles, the trustee role, and that might be a company. Most cases it's a company. And so you'd be looking at, well, who do I leave the shares in that company to? If you want your children to equally be in control of the decisions about that trust, you'd probably leave the shares in that trustee company to them equally, or in their testamentary trust equally. With the appointer role, and as I mentioned before, the appointer hires or fires the trustee. So if they don't like what that trustee is doing, they can take them out and put a new one in that they might have control over. So in a sense, they're the ultimate controller of the trust. So we need to look at those 2 roles. And there are lots of options around that. We might create a corporate appointer so that all your children have a voice in relation to that. We might dissolve the appointer role altogether so that it's just the trustee with those powers of appointment. And so the trustee can just operate as the corporate trustee in perpetuity for the lifetime of the trust. And if all the children through their testamentary trusts, which then includes their lineal descendants, have a voice in relation to that trust, then they'll all have joint control. If one thing you do need to be wary of in appointing successor appointors is if you might make your spouse first off the successor appointor, but then if you appoint a successor appointor, say your children jointly, one thing to keep in mind, and it's not often an immediate thing, like you'll have other opportunities to change this as you get older, but it's basically survival of the fittest. So the last surviving appointor will be the person ultimately in control of the trust. So if you've got 2 children, you appoint them both as appointors, but then one of those children dies, then the surviving appointor will be the only one in that role. So then they could technically remove the trustee and put someone else in that they have control over. Changing trustee and appointor roles won't trigger a resettlement of the trust. So, that's okay, and that's why we look at that control aspect of the family trust. One other thing, and I won't get into it, and you can jump in with any technical stuff here, Shane, about unpaid present entitlements and loan accounts. But one thing to be wary of, and this is why we'll often ask for the financial statements of the trust, is that if there are big loan accounts to individuals or unpaid present entitlements in there, they're assets of that person's estate. So if, say, someone's owed $500,000 from their trust and they die, sure, we can do whatever we want, fancy things with the control of the trust, but their estate could say, hang on a minute, we're owed, in fact, they'd have an obligation to call that asset in, we're owed $500,000 from the trust, pay up. And the trust might have to liquidate assets, or, so it can create an adverse outcome. Do you have any other comments on that?
The only other comment I've got is with unpaid present entitlements, which could be profit distributions to companies that haven't been paid. There could also be some tax consequences in undoing those unpaid present entitlements as well. But again, that's another hour conversation about how all that works. So
but just highlighting another thing to look at as part of it. Again, look at the governing documents, the trustee constitution, and if there are any. So with the buy-sell agreements that we talked about before, quite often the family trust will be the shareholder in a company, in a business. And so, the way that all works with insurance going to the individual, and then, but the shares being sold by the company, by the trust, and then the trust has a capital gains tax liability. So it's important to work through all of those scenarios as part of your succession plan for the trust. It's not as straightforward as just saying, oh, I know I own those assets in a trust structure for asset protection reasons or whatever, but they're part of my wealth and this is who I want it to go to. It's not that straightforward. Does that answer your question earlier? Yeah. Okay, excellent. Now, oh my gosh, I'm going to have to speed it up. 10 minutes. Okay. All right, we'll breeze through this. But the reason why I put this topic in here is because it's a question I get a lot. And that is when parents lend money to children, because we all know how hard it is to get into the housing market, and so they'll often lend money to their children to do that, or give money to their children, and that's the distinction that we need to look at. So our general advice is, well, instead of giving it to your children, because if you give your children a sum of money, that's theirs. They can do what they like with it, which you might be quite happy for that to happen. But it also then forms part of their assets if, say, they have a relationship breakdown, or they get themselves into a financial pickle and end up going bankrupt. So, that you might not want it to be categorised as a gift in that situation, and you'd prefer it to be a loan. So a couple of points about that. There is a presumption that if you've provided funds, so say you're providing $500,000 for your child to buy a house, you advance that $500,000 to them. There's a legal presumption that the provider of the funds is the beneficial owner. If you can establish that you've provided the funds, then you're the beneficial owner of, say, that property. But that resulting trust is displaced, that presumption is displaced by certain relationships. It's displaced by a spousal relationship, and it's displaced by a parent-child relationship. So in that situation with certain relationships, it's not considered, you're not considered the beneficial owner if you've advanced the funds, it's considered a gift. So that's where we start from, it's considered a gift. If you want it to be categorised as a loan, then the key to making it enforceable is to make it as commercial and arm's length really as possible. So in writing, rather than just I'm lending you this money verbally, not backdated, or if you've already done it and you're trying to fix what you've done, to that second point there, it's very difficult to reclassify a gift as a loan, but rather than do a loan agreement that you backdate, do a record of a prior oral agreement. Like, we agreed that this was a loan on this date, this is recording what was the terms of that agreement by way of deed, because past consideration is not good consideration, so you can't make it binding by just doing a normal agreement. You'd need to do it by way of deed. Charge interest if you can. I mean, a lot of people don't want to do that. So you don't have to charge interest, but I'm just pointing out the things that would make it more enforceable. So if you charged interest on it, it would be more enforceable. If you had repayments made, even if they're nominal, then it will make it more enforceable, and it will also prevent, by having regular repayments, even if it's a nominal sum each year or each quarter, it will also refresh the loan and avoid the risk that it will be statute barred. So there's a Limitations of Actions Act that says that a loan can become stale if there's no repayments, no attempts to enforce it, what do you call it, Peter? No steps are taken to enforce the loan for 6 years if it's unsecured, 15 years if it's secured by way of, say, a mortgage. So there are a couple of ways of addressing that. Either you can refresh the loan within those periods, so you can have the loan, say, end in 6 years' time, but just make sure you refresh it at that point, or you can just have a written acknowledgement that, yes, I still owe this money and under these terms, but just be aware of it. Make sure you diarise it, or have regular repayments, because that will constantly refresh it. Security, if you want to make it more watertight in terms of protection, if you're trying to protect that asset, then if you take security, like say by way of mortgage, so you lend $500,000 to your child. We'll take Henry, I haven't mentioned him. So Henry, I lend $500,000 to Henry. He buys a house in his own name, or maybe even with his partner, and that $500,000 is reflected in a formal loan agreement that it's owed back to me. It would enhance my position and enhance the protective nature of that asset if I also took a mortgage over the property. Because then if anything goes pear-shaped in Henry's life, so he runs into financial difficulty, or there's a marriage breakdown, there's this liability back to me, so that asset is protected, and I'm a secured creditor, so I'm like the bank in that situation. However, most of the time, I would say that's actually really difficult, because there'll already be a bank there as a mortgagee, and if there's a bank there as mortgagee, they have to consent. Sometimes they will, because they think, okay, well, if you're protecting that asset, then it's also in a way protecting us, but it might impact on their serviceability, and it might mean that they're not given the loan if they've also got this other liability to me, if Henry's also got this other liability to me. So obviously, best case scenario, registered mortgage over the property. If you can't do that, and you had a question about this recently. Yeah, so because even with an unregistered mortgage, for example, you technically should be getting the bank's consent for that. If you send your child off for independent advice, that's another way that it can be more enforceable, because they've had independent advice on it. So it's not trying to pretend that a fake watch is genuine. Consider the tax implications though as well, because if you're charging interest to your child, then that's income. So, that's part of your taxable income. But also if you're a pensioner, and it could then impact on your Centrelink benefits, for example. So just consider those tax implications and talk to Aintree Group about that. Also, really important to consider the interplay with your estate planning. So you might have a hotspot clause in there, so where you say, well, I've advanced XYZ to this child during my lifetime, so that needs to be taken into account to equalise the estate as part of the distribution of my estate under my will, so that all my children benefit equally. So you can have some sort of equalisation clause in there. Or if it is reflected in a formal loan agreement, that loan can be then transferred or gifted to, say, the testamentary trust that is set up for that child. So then that child individually, personally, owes that amount of money to the testamentary trust, and then that's also a way of then getting those funds back into the testamentary trust and equalising the estate, because that's an asset that's just appropriated as part of their share. To Peter's point, it's also, you know, the best way of protecting that provision of funds by a parent to a child is to say to the child, well, I'm going to give you this money if you get a binding financial agreement with your partner or your spouse, which essentially quarantines that contribution that's been made by the parent. So if there is a relationship breakdown, then that money comes off the top and back to them. So, you know, that's a conversation worth having with your children when they're getting to that age and are in relationships, but you're also, you know, funding certain things for them. Also a great opportunity to encourage them at that point to make their own wills. Could even make it a condition of giving them their money, that they have their own will in place, that because it can specifically mention that, and at least by acknowledging that loan in their will, there's not going to be any dispute as to whether it was really a loan or it was a gift, and you know that it will just make it clearer. And they can then also appoint the executor that they want to appoint. They're not going to have issues with potential challenges to the will if they want their assets to go in a particular way. So really important that it all aligns. And I'll cover off on enduring powers of attorney really quickly because I know I've got maybe 1 minute. Or no, 1 minute, I do. Okay. Really important to plan for incapacity during your lifetime as well, not just what happens when you die. So if you lose decision-making capacity and you don't have someone appointed to make decisions for you, then the solution to that is going to VCAT, a loved one going to VCAT to get an administration or a guardianship order to act on your behalf. Then there's lots of hoops to jump through. Delivering up accounts every year, getting consent for certain transactions. Much simpler to make sure you've got it in place beforehand. The thing to remember is every state in Australia has different documents, different requirements. And so if you've got assets in other states, sometimes we'll do multiple powers of attorney that don't revoke each other so that you can easily deal with, say, property in Queensland or New South Wales where the power of attorney, or Western Australia where the power of attorney has to be registered. But in Victoria here, you would have an enduring power of attorney for personal or financial matters. Personal matters are things like where you live. Financial matters are things like transacting on bank accounts, buying, selling assets, signing documents. Importantly, acting in relation to your super fund. So as trustee of your super fund or director of the trustee company. So really important in relation to that. We also have a separate medical decision-making form where you can appoint a person to make decisions for you if you lose capacity to refuse or consent to medical treatment. Who to appoint is what you need to think about. How should they act? If you've appointed more than one person, should they be able to make decisions individually, severally, or do they have to all agree? When does it kick in? Does it kick in from when you sign the document, so immediately, or only if you've lost decision-making capacity? Keeping in mind that that has to be certified by a doctor, and so it can be a little bit of, there's a grey area when people can't really make decisions for themselves, but they technically haven't lost decision-making capacity from a medical or a legal standpoint. You can provide directions and about how they need to act or give different people different powers. And they're all the different decisions we would work through. Okay, so key points. Be open. You know, we're asking you to be open with us in sharing, you know, what you have, what your assets are, where they're held, how you want them to be distributed on your death, and most importantly, who you want your assets distributed to or your wealth distributed to, and also who you want to appoint in those key roles. But not only be open with us and, you know, our team, we sort of all work together to make sure from a financial accounting point of view, a planning point of view during your lifetime, and also a legal point of view, that you have the infrastructure in place to enable you to do this. But it's really important, particularly as, say, kids get older, or, you know, you have wider family members or people you've appointed, that they also understand what you're putting in place and why, particularly with adult children. If you involve them in the conversation, and it doesn't have to be straight away. We often will facilitate, those family meetings where we can explain the basics of, a testamentary trust and why the parents have set it up in this way. But it is really important to have those conversations while you can explain it, while you're alive, rather than leaving it until after you've died, when the people don't really understand what you've done and why. But that's when conflicts can occur, because you don't have an opportunity to explain it after you've gone. And we can certainly help you through this. Consider testamentary trusts as a tool. Remember, it's more than just a will. There's superannuation and other entities to consider. Get advice on the tax implications, but as we pointed out before, that shouldn't be the only driver. There are often personal reasons why you want things to go in a particular way. Plan for now as well as with the end in mind. So don't just think about what happens when I die. Put the infrastructure in place now while you're alive. So with your business and your trust, make sure your deeds are up to date, your shareholders agreements are in place, your attorneys have been appointed, which all operates while you're still alive. Get the financial advice on recontribution strategies or whatever it might be. So, and your structure, the best structure for you. So don't just leave it for when you die, and review it regularly. So we touched on this earlier, but we would generally say, have a look at your estate plan every 3 to 5 years or so. Some people will do it every year. Doesn't mean you have to update it every year. You don't have to go through this big process every year, but just look at it, make sure it still meets your requirements, that things haven't changed. And obviously, if an event happens, someone dies, your asset position changes dramatically, children are grown up or married, you have a relationship breakdown, all of those things are triggers to have a look at it.
The calendar reminder in your Outlook or whatever it might be, for 3 years' time or whatever, to say review my estate planning, just so it prompts you, because you might forget.
Yeah.
So
and 3 years goes like that.
It does. Yep.
I know I've gone way over time, but I hope it was beneficial for everybody. Does anyone have any questions? And if you think of anything afterwards or anything's unclear, email Chelsea and she'll pass it on, and I'm happy to answer that offline. And yes, and Chelsea will also email me all the very honest people that have let her know whether they answered the questions correctly, so that I can send my surprise.
That's great. Thank you, Sophie. I thought that was fantastic and very thorough. And I continue to learn through this process as well. So it's very complicated, and you've done a great job in presenting it all. And yes, it's a tough gig to get through all that content in such a short time. So well done. So thank you everyone for coming in person, and thank you who are online for this as well. So absolutely, if you've got any questions or want to follow up with any further advice in this area, please contact Aintree Group Legal, Sophie and the team at Aintree Group Legal. And thanks very much for attendance, and have a good rest of the night, and keep dry with the weather that's coming in the next day or so, and potentially over the weekend. So thank you everyone for attending.
Thank you.
Thank you.